What is the common link between acclaimed Bharatanatyam dancer Sudha Chandran, prominent sports personality Boniface Prabhu and entrepreneur Shrikant Bola, or Homer, Milton, Mozart, Beethoven, Byron and many others? Well, they all overcame their disabilities to scale extraordinary heights, braving all adversities. Acknowledging the contribution of such personalities, the Supreme Court on Tuesday delivered a significant judgment that is likely to broaden the horizons for the differently abled in the country. A three-judge bench led by Justice B.R. Gavai held that mere existence of a benchmark disability cannot be a ground to disqualify an individual from getting admission to an academic program. Such candidates, it said, cannot be declined admission unless an assessment is made that their handicap would be a hurdle for them in pursuing a course. With this path-breaking ruling, the bench approved the admission of a medical aspirant from Maharashtra whose speech and language disability was quantified at 44 to 45%. The petitioner, Omkar Ramachandran Gond, was denied admission on the ground that his disability exceeded the benchmark disability, which is 40%. The term benchmark disability found in job applications and college forms refers to having at least 40% disability of any type recognized in the Rights of Persons with Disabilities Act of 2016. Under this law, government and government-aided higher institutions have to reserve 5% seats for the disabled, while a 4% quota has to be provided in government jobs for them. Gond had sought admission in the MBBS program under this quota, which is called the Persons with Disabilities or PWD quota. However, as I mentioned earlier, Gond was not given the benefits of reservation because his disability was found to be more than 40%, which is the benchmark disability prescribed in the law and incorporated in the Graduate Medical Education Regulation of 2019 that governs admission to all undergraduate and postgraduate medical courses. But while highlighting some of the salutary provisions of the 2016 Disability Law, which aim to facilitate full participation of the disabled in the society and make them live with dignity, the bench cleared Gond's admission. The bench, also comprising Justices Arvind Kumar and K.V. Vishwanathan, also issued a set of directions to the Disability Assessment Board that have the power to issue disability certificates after quantifying a candidate's handicap. The court said such boards should not function as monotonous automations to merely check the percentage of disability, but must focus on how to accommodate and provide opportunities for candidates with disabilities rather than seeking ways to disqualify them or hinder their educational goals. Before understanding how the Supreme Court arrived at its decision, let me quickly do a recap of how the matter reached the top court. Gond, who is the son of a middle-class family in Latur, Maharashtra, sat for the National Eligibility Cum Entrance Test or NEET this year for admission to an MBBS course. He took the test as a reserved category student under two quotas, the physically disabled as well as the other backward classes. Admittedly, he had speech and language disability and was diagnosed with hypernasality with misarticulation. A disability certificate issued to him in May 2015 certified him to have 45% speech and language disability. Gond qualified in the NEET and was selected for counseling as well. Since the admission regulations required him to submit fresh disability certificate, he approached the designated Disability Certification Center at Sir J.J. Group of Hospitals in August this year. The certificate issued to him reiterated the percentage of his disability and along with that declared him ineligible to pursue a medical course as per the norms of the National Medical Commission or NMC, which is the regulator for medical education in India. In view of this opinion, Gond was not given admission in a medical course which he challenged before the Bombay High Court. Gond questioned the Graduate Medical Education Regulations of 1997, which were amended in 2019, that prescribed the disability benchmark as 40%. Gond could not get interim relief from the Bombay High Court. The court issued notice on his petition on 29th August but did not allow him to participate in the centralized admission process for the MBBS course. The High Court simply stood over the matter to 19 September 2024. But with time running out for him, Gond moved the Supreme Court, raising the question on whether a candidate could be disqualified merely because their disability is quantified at 44 or 45%. Before proceeding further with the hearing, the Supreme Court ordered Gond's fresh medical examination, which was done by Delhi-based Maulana Azad Medical College. In contrast to the opinion of JJ Hospital, Mumbai, the MAMC board opined that Gond's speech and language disability would not come in the way of pursuing the MBBS course. Armed with the fresh assessment report, the Apex Court paved the way for Gond's admission by providing purposive interpretation to the 2016 law on reservation for the disability. Purposive interpretation is interpreting statutes and constitutions in line with the law's purpose and context. The SC drew support from the Directive Principles of State Policy chapter of the Constitution that calls for equal opportunities in education as well as the workplace for aged, sick and disabled persons. The government, the court observed, is required to achieve this constitutional goal by making effective provisions for securing rights for such a vulnerable group. The bench discussed some provisions of the Rights of Persons with Disabilities Act of 2016 as well. It gave a broader meaning to the phrase reasonable accommodation mentioned in one of the crucial sections, which is Section 2Y. Section 2 talks about the government's duty to ensure that people with disabilities have the same legal capacity as others in all aspects of life. Section 2Y specifically allows authorities to modify regulations in order to ensure that persons with disabilities are able to exercise their rights equally with others. According to this subsection, reasonable accommodation means necessary and appropriate modification and adjustments without imposing a disproportionate or undue burden in a particular case. Stressing on the importance of subsection 2Y, the court said that the concept of reasonable accommodation would include making necessary adjustments to ensure equal participation for persons with disabilities. Adjustments or modifications cannot be understood narrowly to include only the provision of assisting devices and other tangible substances which will aid persons with disabilities. Only a broad interpretation of this concept will further the objective of the 2016 Disability Law and Article 41 of the Directive Principles of State Policy, the bench said, as it directed the disability assessment boards not to be antithetical to the objectives of the law. The court came down heavily on such boards for evaluating candidates mechanically and directed them to state reasons for declaring someone ineligible to pursue a course.